Hello everyone. The unit we'll be doing today is 3.29 legal terminology and communication. My name is Shazia Khan. We'll be doing learning outcome today, which was to be able to present information in a legal context orally. But firstly, we'll be summarising what we did in the last session, which was learning outcome 1. In the last session, we looked at what is communication, the importance of communication, and what is legal communication. And legal communication occurs both in adversarial and transaction contexts, required to achieve the legal goals of, for example, if you wanted to make a will, to negotiate a contract, or offering to buy any properties. We also looked at what is verbal communication, with reference to opening communication. We looked at basic verbal communication skills, effective speaking and listening. We looked at non-verbal communication, being prepared to listen, oral communication, which includes individuals conversing with each other, be it direct conversation or telephonic conversation. Speeches, presentation, discussion, and all forms of oral communication. We looked at the advantages of oral communication and the disadvantages of oral communication. We also looked at the elements of written communication and wordless communication, and good writing skills, and why they are so important. For example, it allows you to communicate your message with clarity, and ease to allow for a larger audience. And we looked at face-to-face telephone communication too. We looked at the issue of the characteristics of verbal communication, what they are. We looked at the issue in regards to non-verbal communication, so includes things like, facial expressions, the tone, the pitch of your voice, gestures displayed through body language, and signs. Things like non-verbal communication can be things like you convey something through an emotional state, so your facial expression, your tone of voice, and your body language can often tell people exactly how you feel. For example, if someone said to someone, "Are you okay?" and you look a bit down, we know how people feel from non-verbal communication. We also looked at interpersonal communication and why that is so important. Non-verbal communication in writing. We also looked at wordless communication, as mentioned earlier, and formal communication, how this is controlled and what channels it goes through, and how messages are exchanged through formal communication, the characteristics of formal communication. We looked at informal communication and the difference between formal and informal communication. We also looked at the grapevine communication, which is quite popular in some organisation, and is an informal communication route, and it's therefore it's a form of unstructured communication, and it operates both external and internal channels. We also looked at the importance of grapevine communication, how it also speeds up feedback loop, is a practical way to send communication as well. We looked at the types of grapevine communication: single strand chain, gossip chain, and probability chain. And we looked at, as mentioned earlier, the key differences between formal and informal communication. We also looked at the benefits of effective communication and how it helps within an organisation. So things like increasing effective employer engagement, improved productivity, improved client relations, also improved job satisfaction, strengthening things like team building. And we also looked at the barriers to effective communication. So things like language barriers, psychological barriers, physical barriers, and things like emotional barriers. Sometimes people find it difficult to express their emotions on certain topics. So we looked at them in elements of why communication is important within a legal context as well. Now, learning outcome 2, we're going to be looking at being able to present information in a legal context orally. So we'll be covering the following. We're going to use different styles and methods of oral communication for different audiences. We'll be looking at information in a legal context, orally in a formal situation using correct legal terminology, to respond to questions arising from presentations of information. So 2.1, use different styles and methods of oral communication for different audiences. Oral communication. Oral communication is the process of expressing information or ideas by word of mouth. It is the process of verbally transmitting information and ideas from one individual or group to another. Oral communications can be either formal or informal. The process of exchanging information, thoughts, and ideas through spoken words is commonly, as we mentioned, referred to as oral communication. It is a fundamental form of human communication that allows individuals to interact, express themselves, and convey messages directly to others using speech. Oral communication covers various aspects, including speaking, listening, and understanding. It is a dynamic process involving both verbal and non-verbal cues, such as tone of voice, facial expression, gestures, and body language. Important for oral communication: clear pronunciation, precision, conviction, logical sequence, appropriate word choice, and natural voice. The nature of oral communication is essentially dynamic and interactive. Unlike written communication, which relies on written words, oral communication involves direct interaction between individuals through spoken word. It allows for real-time exchanges, immediate feedback, and the ability to respond to the needs of situation and audience. So types of oral communication, we've got face-to-face. The majority of communication in a business is face-to-face. Communication with stakeholders is often face-to-face too. A customer may enter the business to talk to someone about their needs, requirements. Immediate feedback is given, and the sender can thus make sure the message has been received and understood. There's no written record of face-to-face communication. Face-to-face communication is when two or more people interact and communicate while visible to one another. This might be a physical in-person conversation, or it could be in a virtual setting. Face-to-face communication is often more effective than written or audio-only conversations. This is because seeing one another allows us to pick up on non-verbal cues and body language. And because a lot of communication is non-verbal, being able to see each other helps us understand each other better. Good leaders know that face-to-face communication helps them connect with their team members. For example, when you have a difficult conversation with an employee, you know it's best to be done face-to-face. Speeches and presentations. This refers to the stand-up podium speech delivered by an individual from an outline or script. Also includes group presentations or impromptu speaking. A strong element of monologue, but dialogue can be built in with question and answer or discussion with the audience. This type of communication involves one individual speaking to a large group of people. Public speaking is often used for informative or persuasive purposes, such as delivering a speech, or presenting a proposal. Discussion groups. A structured discussion of a topic of common interest from two or more points of view. Discussion typically involves participants who argue one side throughout, while deliberation allows for movement by individuals within the process. Often leads to creating an atmosphere of collective, out loud thinking about some question, idea, problem. There may be some written informal records for noting down important points. Group discussions involve multiple participants engaging in an exchange of ideas, opinions, and perspectives on a specific topic. As mentioned, this type of oral communication enhances collaboration, problem solving, and decision making within a team. Telephone calls. Telephone calls are often are a form of informal communication. In business, telephone communication can be internal or external. Immediate feedback is given, and there's no written record of the conversation. Telephonic communication is useful for situations where face-to-face communication is not possible or practical, such as in long-distance relationships or business negotiations. Oral communications, advantages and disadvantages we'll be looking at now. So advantages of oral communication: time saving, quick feedback, application in special areas, powerful means of persuasion and control, saving money and effective for all. It's more reliable, its flexibility, and its complete understanding. The disadvantages of oral communication: emotion, there's no legal validity, absence of permanent record, problem for distance people, unsuitable for lengthy message, confused speech, greater chance of misunderstanding, distortion of meaning, uneasiness to fix responsibility, and risk of leak of secret information. Oral communication is less authentic than written communication, as they are informal and not as organized as written communication. Oral communication is time-saving as far as daily interactions are concerned, but in a case of meeting, long speeches consume a lot of time and are unproductive at times. 2.2 we'll be looking at now, which is to present information in legal context, orally in a formal situation using correct legal terminology, and 2.3 to respond to questions arising from presentation of information. So the role of argumentation in law. A lawyer must justify his case with arguments. A judge must support a decision with arguments. In many legal systems, the judge has a legal obligation to justify his decision. The legislator must support his proposal with arguments, and a jurist must justify his opinion with arguments. Someone who presents a legal thesis is expected to put forth arguments to support it. A lawyer who brings a case to court must justify his or her case with arguments. The judge who also takes the decision expected to support his decision with arguments. And for example, a judge, if he had to take a decision in regards to sentencing someone with a lengthy sentence, he must be able to identify that, you know, the sentence he's given, he must be able to argue the point that why he's given that sentence, and also refer to the sentencing handbook. In law, argumentation plays an important role when someone presents a legal claim and wishes this claim to be accepted by others. A lawyer who brings a case to court must justify his case with argument, as we mentioned earlier. Dialectic and rhetoric in legal argumentation, logical approach and rhetoric approach. The logical approach emphasizes the formal aspects of the legal argumentation. The rhetoric approach emphasizes the content of arguments and the context dependent of acceptability. Dialect proceeds by questioning with answering, while rhetoric, for the most part, proceeds in continuous form. Either rhetoric, as it relates to arguments and argumentation, is to have rational persuasion as its goal, in which the case rhetorical commitment to reasonableness means that the norms of rhetorical imply those of logic as applied to arguments, of a dialectic as applied to argumentation. The logical approach. The necessary condition of the acceptability of a legal justification is that the argument underlying the justification can be reconstructed as a logical valid argument, as by George Kalinsky. According to Ulrich Klug, a legal argument can be reconstructed adequately in terms of predicate logic. The rhetoric approach. The acceptability of an argumentation is dependent on the effectiveness of the argumentation for the audience to which it's addressed, by Chaim Perelman's particular concrete audience, a magistrate or a jury in a criminal trial. In particular, awareness of rhetoric allows a lawyer to analyze his audience, often a judge, and better communicate inside the courtroom. In the courtrooms, lawyers practice the skill of rhetorical to persuade the judges. Audience analysis in oral communication. So we've got the experts, and these are people who know the theory and the product inside and out. They designed it, they tested it, and they know everything about it. The non-specialist reader is least likely to understand what these people are saying, but also has the least reason to try. These are the people who build, operate, maintain, the technicians. These are the people who build, operate, maintain, and repair the stuff that the experts design and theorize about it. There is a highly technical knowledge as well, but of more practical nature. Then we've got the executives, and these are the people who make business, economic, administrative, legal, governmental, political decisions on the stuff that the experts and technicians work with. It is a new product. They decide whether to produce and market it. If it's a new power technology, they decide whether the city should implement it. Then we've got the non-specialists, and these readers have the least technical knowledge of all. Their interest may be as practical as technicians, but in different ways. They want to use the new products to accomplish their tasks. They want to understand the new power technology enough to know whether to vote for or against the upcoming bond election. Then we've got the 4 Ps in the legal argument. So we've got planning, practice, preparation, and perform. And we'll go through each one so you've got an idea of what they are. So planning is to define a purpose, analyze the audience, and analyze the occasion. The practice is to rehearse before presenting to an audience. So you know when you're going in, you know what you're going to talk about. Focus around central argument and be assertive. The preparation is develop the central idea, to develop main ideas, to gather information supporting your ideas. And then to perform, begin with confidence, be organized, because you want to go into a courtroom being organized, having your cases, having all the evidence together, use appropriate visual aids, and pay attention to your audience. So, refer to what the judge is saying, what the jury implements, and also the Crown Prosecution Service. When we, to conclude, we look at the role of argumentation in law and why it's so important. In law, argumentation plays an important role when someone presents a legal claim and wishes this claim to be accepted by others. A lawyer who brings a case to court must justify his or her case with an argument. Instructors assign argumentative writing so students can learn to examine their own and others' ideas in a careful methodological way. Argument teaches us how to evaluate conflicting claims and judge evidence and methods of investigation. Argument helps us to clarify our thoughts and articulate them accurately. Communication skills are essential for lawyers to effectively communicate with clients, judges, jury, and other legal professionals. Lawyers must be able to explain complex legal issues in simple terms, persuade others to their point of view, and negotiate favourable settlements for their clients. So to conclude, communication is very important in regards to the legal sector and legal argumentation, and the identification of argumentation communication is really important in regards to when lawyers are presenting cases. They're able to argue their point and they're able to define purposes, but also gather supporting evidence and develop ideas and make sure they're organized. So now we've finished learning outcome 2 in regards to legal terminology and communication. And these are some of the references that have been used for this session. So Fetteris, Fundamentals of Legal Argumentation; Hague, Legal English; Routledge; Korn, J, Oral Communication Skills in Law Course; Locker, Power and Politeness in Action, Disagreements in Oral Communication; McCroskey, J, An Introduction to Rhetorical Communication; and Walton. So just have a look at some of these references to help you, support you in regards to your assignment. And thank you for your patience, and thank you for attending today's session. And I will see you in the next session, which will be learning outcome 3. Thank you for your patience. Thank you. Bye.